Hello, my name is Jeff Hayes, and this is a summary of the evidence of my case of CF 2014-343. Now, a lot of the conversation you'll hear me on this is from my personal experience, and I witnessed in the court, and so you, after watching this, I'm pretty sure you'll come to the same conclusion and everything that I came to as this was happening to me. And you'll be surprised, because I know, every time I look at this evidence, what the hell were these people thinking? And I have other videos coming out in more detail, so of business and stuff like that, so you enjoy. Alright, my name is Jeff Hayes, and I'm going to go through a quick summary of what happened to me in my case. And we're going to start out, and I'm going to show some pertinent information, and we'll leave out basically a lot of the details, but there's enough evidence here to prove my case that something very bad, something very wrong is going on here. And you'll see that it's kind of like on the prosecution side and everything, and this is through personal experience and the paperwork that I'm going to get ready to show you. This is actual Oklahoma rules and regulations. This is actual whatever conditions, so don't let nobody mess with you on this, because I am pretty much an expert on this, because I've got 30 plus years in the workforce and experience training of doing it right and legally. In this area, Bryan County, Durant, Oklahoma, this is the only place I've worked at that the companies in this area are bad, really bad. And if you'll ask anybody, before all this went down, I was already buying new clothes and ready to move from this area and get a job elsewhere. But after this went down, I'm not leaving until it's over with. And I've already contacted attorneys, and it's going to come full circle. But today's going to be a quick summary, and I'm going to show you the evidence as I saw it, and I'm going to explain the law. Now, I'm not a lawyer, but I know what you have to do and what you can't do. Now, I do know a lot more about business law and what business can legally do and what they can't do, and who's responsible, and what you can call training and what you can't. I also know in felony cases you can't make accusations unless you back it up. The prosecution, whether it's in an appeal or not, they have to back up any accusations they make. They have to give full disclosure at any time. They can't. Once you have the discovery period of every case, this is included in misdemeanor and federal cases. And felonies are federal, which means they have a higher standard that has to be followed to the letter. It must, because the severity of the punishment in a federal case can be life imprisonment to death, and a felony marks you for a long time. So a lot of responsible states have a grand jury in place to keep their state and their counties from being sued. It also keeps their district courts from the influence of corruption, which is rampant, and we'll get into that later. So we're going to start out. This is Oklahoma. This is your standard Oklahoma drug testing rules and regulations. This goes for any time that you're going to be tested. And we're going at employee testing. When you first initialize this, or you're going to a drug testing, random drug testing, it tells you 30 days advance notice of the policy to where there's disciplinary action or a potential of it for any positive test result. You have to give them 30-day notice, and this goes for it says here scheduled and mandatory test. Drug testing is mandatory for these people here. But in your company, by your company's original drug and alcohol workplace free, whatever, the only time with that policy that you can be tested is if you or in an accident on a company vehicle or whatever while operating it, or operating a machine where you're personally hurt or destroy company property, or you are acting suspicious, where that constitutes a testing. Now, there's several different kinds of things they call a test, but they're not. Now, you have your UA, that's not a drug test. That's a urine analysis derived from testing urine for infection and stuff like this. Women use it a lot because they develop all different kinds of infections, yeast, whatever. We'll not go into a whole bunch of that, because whatever. But they found out through the use of that they can test, they can check for certain chemicals in your urine. Well, you know, we'll get into that, but this test can only prove beyond a shadow of a reasonable doubt when you take it, this test, or UA, that you've been exposed to it within a certain amount of period of time, days or whatever. It doesn't prove that when you clocked in, you were under the influence. That by law, and this is by the workforce, federal labor law, the only thing is a blood test, because that actually shows the amount or percentage in your blood that proves you under the influence or intoxicated or whatever. That's the same with alcohol. At the time of the test, when you clock in, that is the only test where you violate that rule and regulation, that they can prove that you're actually under it. Follicle test cannot prove it. They can't tell if you were there. It's not that accurate. The UA is not that accurate, and we'll go into later. I'm going to have a film on that. But the only two that the follicle and the UA can only 100% test for is that at one time or another you were exposed to something, this substance. It doesn't prove you took it willingly, and it can't nail it down to the time. What these two tests do is, if you're an hourly worker, it's an invasion of your privacy, because if you're an hourly worker, the company can only be held by your company's rules and regulations and policies while you're on the clock. While you're not on the clock, they have no say. If you catch them around your house spying on you, you can have a restraining order put against them, harassment, anything. If you're not on the clock, they have no say in your life. If they try to hold your private life or anything, or actions while you're not on the clock against you, that's illegal. They can't do it. They can only do that to a salary worker. Okay? And that includes, like, if they call you on a weekend to try to get you to come in, you don't have to answer the phone. And you don't. And if you read that text that they sent you that says you need to come in, you're not on the clock. You don't have to obey them at all. So don't let them intimidate you on that. If they take any disciplinary action against you, you have legal action, because you have rights. If they come around your house, that's an invasion of privacy. I mean, until you're on the clock, they cannot tell you what to do. That's the law. Now, here with this is different things. Now, this is also too interesting. Conditions and methods of this. Testing facilities must be duly approved by the health department. Specimens should be collected and tested by qualified people, and this means filling out the paperwork too. I mean, because the procedures must ensure privacy, confidentiality of the test. Confirming tests must be conducted in case of positive findings. And the reason why they want it by the health department is from cross-contamination. People using the right condition. That's why it says qualified. A qualified person that takes any one of these UA testings or follicle or blood tests must wear the proper sterile equipment. They must do the proper handling procedure and be qualified to fill out the paperwork. Because anything that you render your signature to, once you sign it and their part is done, they cannot alter that paperwork. They cannot add to it. They cannot amend it. They cannot tamper with it in any way. And we're getting to why you can't, because that's federal. That's fraud. If they alter it or amend it in any way, you have to be present, because your signature's there. They have to do it in front of you, and to show that they did it in front of you, you have to initial it and date it in your own handwriting. Nobody else can do it. This is to ensure that you're not getting set up for something that false accusations and stuff. That's part of being a qualified person. Now, there's a lot of companies around here that will do like deceptive things, like saying that they're enacting a random drug test policy. Well, this has to be enacted just like any policy in the company. This does not automatically go with your regular workplace, drug policy. This is an add-on to it. So it's separate but works hand in hand. And this includes everybody. Must be in the pool to have the opportunity to have their name picked. And it is per shift. You either test one person on that shift, test everybody on that shift, or nobody on that shift. You can't break the shifts up. This doesn't go into it, but each rate, a representative number, a percentage of your employees by race has to be represented to keep from you being accused of and sued for discrimination, favoritism, all that. An example is, like, if you have 50 employees of one race and 2 employees, or let's say 10 employees of another race, now out of the 50 employees, you only pick one person to represent that race. And out of the 10, you pick all 10. That's discrimination right there. The percentage and the number have to represent in your company of that race to avoid being sued for discrimination or anything. The people in your company conducting this must make sure this is done. They must be knowledgeable, qualified, and honest. And to keep it honest, you can't have the drug company or the testing company pick your people, because they can be influenced by bribery, because most of them done now are by private companies, and they don't have an external form of income like your local health department, like they used to use here before private testing companies came here. The individuals in that company can make extra money on the side by making sure certain people test positive. So a way to avoid anything like that is to have a third party that has no interest for computer programming that randomly picks lists. The list must be available. It can't be something that's done just on one shift. Like Russell, anybody that worked at Eagle knows that man, there is something wrong with him. I've never known him do anything ethical or legal when it comes to his shift. I've seen him discriminate against African Americans, Hispanics, and try to get them to quit, put them in positions of horrible conditions. I've seen him have Mike, this one guy that worked there 3 years, make him get up on top of a furnace that did not have the proper cool down time, and he was not given any safety gear, to have him sweep out that like chimney or exhaust thing. And if there's still fire in there and that dust hits that fire in the furnace, that'll ignite, causing safety risks. Anything 6 feet off the ground, you have to have a harness. He didn't even give him a harness. He was trying to get Mike to quit. I witnessed that too. He tried several things on me. He tried writing me up, but he found out soon enough that I know how to work a write-up because I've been an administrator. It works both ways. So then he tried to trip me up and all this other stuff, and it never worked. So when it comes to this random drug testing, if your company uses it on one account and does not do it yearly after that, and you either test one person on one shift, or not test everybody on it, or don't test nobody else. That's like Jeremy on our shift. He goes, well, where's the Hispanics? Well, actually, he said Mexicans. And there were none. He said they were tested on day shift. You can't do that. That's discrimination. It's either everybody or nobody on that shift. You can't break it up. If you want to test both shifts, you have to. If you test day shift, you have to include the front office people. You can't just do one section. It has to be everybody on that shift or nobody on that shift. That's how you prevent discrimination. Now, we're going to get to where I've got, this is online. This is where it all started. Okay, so I'm standing in line to do this drug test with everybody else. Well, this is my original paperwork here. You'll notice It has the time, the date, everything on it. Well, I noticed the guy put his finger in my sample and all kinds of other stuff went wrong on this. You'll see it in a video on my YouTube account about my drug test. They couldn't get, this individual right here could not get the stickers to stay to the container. They wouldn't let me or have somebody bring me my glasses to see the results. So I'm not going to admit to nothing until I actually see it. And if this was up and up on the legit, they would have brought me my glasses. But since it wasn't, I was like, well, and I should have known better, but she said, well, I said, well, the lab. Well, I should have known, well, this was going to not go well anyway, but I figured people are honest. But I come to find out they're not. So this is at the completion. This is when her work is done. Will she give me this copy? That's because the people are supposed to be qualified and knowledgeable of their actions. So the tester will not give you this paperwork till they're done with it. Their part of it's done. You'll notice here, nothing is in a remarks period at all. Nothing. Okay, so they fired me. They said they suspended me, but there's no proof they suspended me. When you get suspended, you get paperwork. So at Eagle, there's no paperwork, and we'll get into that later. Just word of mouth doesn't prove anything. I don't care if you say it's procedure or not. If you weren't there, you don't know what you're talking about. Okay, so this is this. So she told me I had to sign it in order for it to go to the lab. Lo and behold, well, I sent Eagle a nasty email and stuff like this, and that was due to put scare in Rick Roy, because after I seen everything that was happening here, on the day I got arrested for my unemployment case, he needed to be scared, because at the time this was happening, at 2014, Eagle was getting ready to get bought by Dayton Springs, and they were getting ready to get the Mercedes account. So old John Richard Roy couldn't have any proof that he didn't know how to do his job or manage his people or do anything correct. I mean, if you're the operational management manager, then you don't let something run for 3 hours wrong and not know of it. I witnessed that happen. So here I am signing this. We'll go up here again to where I didn't put anything in a remark. She had already done her part of the paperwork. Well, of course, I automatically know, because OESC does not deal in criminal law. So they'll see this drug test. They're looking at this. See this right here? Donor admits to use of methamphetamine. She dates it. Well, that doesn't prove I've seen it. I should have initialed. She should have put this in front of me, initialed, and this. If she added to it later, this has to be done in front of me. Well, she's done with her paperwork and hands me this. This is my copy. She has any reason to write on this paperwork whatsoever, because it's tampering with a signed document, and because of the seriousness of this document, it's a felony to alter it or tamper it at any time without me being present. So she just dates it. I don't know what she was thinking. So there's something wrong going on here. So I didn't know this was on there until it was sent to me through OESC. Now what I did was I got to send a complaint back to this. So I send a copy of this, my copy, and I send along with this copy, and I'm telling them they can't use this due to forbidden fruit law, which deals with tampered paperwork, fraud, which states that if the integrity of this document has been compromised in any way, shape, or form, that any documents that you get use of this tampered with paperwork is also unadmissible as evidence in court. This is federal law on any document that requires a signature that is severe and changes a person's life. This is a felony to tamper with this kind of document. So Rick Roy gets a copy of this because OESC has to do it. Now, OESC cannot make a ruling on this. This is why back in 2013 they amended the appeal process, because it used to be on your first appeal and second appeal you had to go through the tribunal and add whatever evidence. But see, they changed it to where on the second appeal you could take it to small claims court to where they deal with criminal law like this. Okay? So I looked at this and I was like, man, I was horrified at that point. I was like, yep, Fix got to be in. Wonder how much they paid her, because I knew it was a Russell deal. Been trying to get rid of me and discredit me, whatever. So there was no reason for her to put that on there. So somebody made some money somewhere. So I knew I was going to win the case on the second appeal, because I was going to take it to criminal court, small claims court. And small claims court deals with this. OESC and labor law do not deal with this kind of court law. That's why they amended it. Well, see, you'll hear testimony in my court that I had lost my appeal. Well, I knew I was going to lose that appeal, because OESC doesn't deal with criminal law. So I knew I'd win my second one because I was going to the small claims court. So after small claims court, about 2:30 in the afternoon, guess what? Well, they know that Simply Safe is they're primed for a civil lawsuit, man, to be sued. And Eagle could be held responsible, because if this person here decides to rat or squeal, Eagle is implicated in it. And since Russell is a supervisor, that means Eagle can be sued also. That's the law. Because companies are liable for their supervisor, any administrative or management person, because they are part of the company. A company consists of people in positions that can be considered as company are administrative and management people. Your supervised unskilled worker who is hired at entry level and is not trained and is paid minimum wage, well, the minimum the company's offered, is not considered company. They're considered the local workforce, because if for some reason that company moves, they're not taking the local workforce. We're untrained and we're supervised. We're not responsible for anything unless you train us in the criteria and the qualification that our training. Verbal instruction is not training. Watching a video is not training. Anything you want us to do, you have to have a written duties and responsibility for that station or piece of equipment, and then you have to have a training procedure. And you have to check us off on completion of each step. And that goes with handling procedures or anything else, special documents or anything. You have to show procedure protocol. There has to be a training, and your supervised, unskilled, entry-level worker has to be trained on that. You can't verbally, because no 2 or 3 people give the same verbal instructions. And that person you're training may or may not understand it. So it has to be in everyday layman language, in writing, and there has to be a training guide or procedure that follows that, and it has to be checked off by the trainer and checked off by the trainee and initialed at the date it was completed or the completion of each step. That is the criteria for saying in the business world and by law that you have trained somebody. Watching a video is not training. Verbal instruction is not training. If you say you trained somebody, you better be able to prove it. See, and we're getting to that. So they arrest me for trade secrets. I'm like, what? I mean, I know what a trade secret is. And I know the documents that I handled were not trade secrets. These are the common documents that are shipped with the product. When somebody orders it, because you'll get an invoice, you'll get a spec sheet. See, the spec sheets I handled were the diagrams. This was the final product. It didn't show any procedure of the process whatsoever. So here we got a felony that this person and this person are signed to, and it's connected to Eagle. Because again, you only give the copy to the donor after you're done. That is rule of thumb. These people, if you have hired, are supposed to be trained, qualified. You don't let somebody that is not qualified and does not know the procedure handle paperwork this serious. They must know the implications. That's part of their qualification. By federal law, once a document is signed, it cannot be tampered with or altered or amended without the signer's presence, or they have to redo the whole paperwork. And if the donor's copy is not available, or the person who signed it, let's say they came back 2 days later or something and said, we're going to amend this, we have to do it by law in front of you and make an amendment, like to a procedure or something, or a policy law. It has to be amended in front of you, and you have to initial it and date it, just like if you made a mistake on a check. Any correction on a check or anything like that, it's your account, your signature's on that check. You have to initial any correction you made to that check to make it legal. Same thing. So here, Simply Safe is getting ready to be sued. Well, Bryan County's like, well, wait. And Eagle's like, well, wait. So here I'm being charged for trade secret larceny even. Well, Russell and them were letting me take this stuff home. I mean, they passed it out to me, and somebody came by and collected, but they didn't want this spec sheets, because when I worked at this place, this stuff was all over the floor, blowing out the back door. I mean, it was everywhere but where it was supposed to be if it was this important paperwork. And I never saw anything stamped, and I haven't been trained in this stuff, so you would never give a unskilled supervised person anything important to the company. You would never put that in their hands. I mean, that's a rule of thumb right there. And it's John Richard Roy's responsibility to make sure everybody's trained and that the proper paperwork goes to the proper people and to ensure it's being picked up. That's his job. He's the captain of the ship. There's no excuse if it's not done. It's his responsibility. He's running the operations. Well, he's passing the buck, and this is why I got arrested. Now, any document that you sign, so I'm getting charged for this. I don't want to get too far ahead. Any document, this is a basic classification. It says a trade secret is to be unknown to the business circles that normally deal with this kind of information, or trade, like all the leaf spring companies or manufacturers. Eagle has to be doing something that the rest of them don't know in order for it to be a trade secret for Eagle. I mean, if it's something commonly known within their trade or business, it's not a trade secret. Okay, and it gives you conditions on it. This is just basic. This other stuff varies per trade. All right, we'll go into that. Now, there's certain things like formulas, and this is all depending on the trade. Now, food processing and things like where it says recipe. Okay, he used this reference as Colonel Sanders' secret recipe. Well, Colonel Sanders' secret recipe was divided into two sections, both of them locked in a safe in different locations, and no one chef knew any more than 2 ingredients to that. And they did not make this recipe available to the people that worked at their franchise stations. They're unskilled, supervised workers. See, the company is responsible for any procedure or policy they enact. They have to be diligent in the enforcement of it. They can't just lay it on my shoulders. It's above my pay grade. A supervisor, yeah, they can hold to it because they are part of the company. Remember, I'm a supervised, unskilled, entry-level worker that they can't prove any training on, and I'm not part of the company. If the company gets up and moves, they're not even going to ask me to go along. I'm just your local labor workforce. That's it. Okay, so it gives different forms and it gives rights and stuff like this, and it talks about, UK. And this is where we're going to get into certain things. Now, see, at 2:30 in the afternoon, they arrest me for this. They show up, Drew Hell shows up with a search warrant and everything. So I'm being accused of this, and this. And I never asked in any way, shape, or form Eagle for any money. And the DA saying, well, because I was going to lose my unemployment case, I wasn't. The evidence I just showed you showed that was all going to be kicked out by law, criminal law. Because I have proof the integrity of the document that they sent to the lab has been compromised. This is fraud. This is a felony, and I can take civil suit against Simply Safe. due to the fact that this individual, testing individual, should know better. So even though Eagle didn't make, or Russell may have not have bribed or whatever, used his influence on the company itself, he may have done it to this individual. Because apparently she committed a felony for no reason that I could think of, other than money or something, favor, who knows. So there was no proof of a felony, of extortion, because by Oklahoma statute, nothing can be left up to the imagination. The wording must be specific. I must be asking them for something. I must be coming out, and it must lead to it. It cannot be left to the imagination. Okay, now they're hitting me with two things. Well, I posted these. I got fired because of this bullshit, this UA test, and I'm waiting on my. I just got done, and I even have a audio recording of my appeal, and you'll hear on that audio recording, and it's in my YouTube account, where I'm pointing to this forbidden fruit law. I'm leading up to it, and you know, blah blah blah, and this happened at like 9 o'clock in the morning. So they had time to think about it. They knew when I got my second appeal, it was over with, because I was going to regular court, where they do deal with criminal law. Okay, so here, panic sets in. Now, Rick Roy, Eagle Suspension, is paying a lot of money to Bryan County in the form of a donation. Now, a donation becomes a bribe when you expect a return on that donation, or the facility or organization that you're donating to does a special favor for you because you're donating. That's like a payoff. Okay, if they do something you want. Now, reputable companies and stuff, they will avoid doing a special favor because they do not want to be accused of accepting a bribe. They should have stepped away from this. And there's reasons why. Because if you go down further, see, all I did was post this stuff on the internet. And the first time I did it was to help out the people that worked there. Now, during my interview hell, I told him I didn't post this when I worked there. Now, how he messed that up, I have no idea. Now, here you've got Emily Redman sworn that she is examined and duly whatever, that I've committed these crimes. Now, you have two dates here. Now, on a conviction paper, these dates are different. They manipulated this stuff, and in federal, and even in when it's a misdemeanor, you have to have the exact evidence. They're accusing me, now these are actual documents, but not in the leaf spring industry or trade. This is electronics over. So here the evidence is messed up, and this is a felony case. You cannot do this in a felony case. This is proof of incompetence and not being able to work a felony case. Because the same evidence you are trying to prosecute me on has to follow through to conviction. Through my whole trial, I did not see one schematic was ever proven. They did not change this during the time of discovery. After discovery is over and you don't present the proper evidence, if you go to prosecution using this, you're screwed, because this is not the right evidence. So you can't convict with this evidence. You can't prosecute. You must drop the charges. You must get your evidence right, and then you can recharge somebody with it. If you proceed with this the way, it not only shows that your incompetence level, that you're not fit to try this on a federal level, or any level really, when it comes to business, that you're on a bribe or something. Somebody's rushing you to take action. You got to earn that money. See, and here's schematics again. And they're saying they're approximately valued at $10,000. No, they're not. That is your licensing fee to get these documents. This is like, okay, every automotive industry farms out their leaf springs because they cannot keep that department open 24/7, because they'll use the same spring assembly on the same frame and just change out the cosmetics and chassis. So Eagle has a deal with the automotive companies that they will provide at the lowest bid to the automotive company, and the automotive company will buy springs that Eagle is making, OEM, to put on their assembly line cars. Now, see, don't get confused by this, because any leaf spring company can get a license to manufacture that same OEM part, but they'll have to pay $10,000. This is considered the cost of doing business. Now, with that $10,000 in that license to manufacture, because back when everything was unionized in the automotive industry, they set up rules and regulations. In America, you have to have a license to manufacture anything in the automotive industry. That's part of that automated process. You have to pay a licensing fee, and you get a license. And part of that, you get the specs, because Eagle doesn't make any of its own products. That was apparent in the preliminary case, which it should have been dropped then with this evidence. Okay? They get dimensions. And so they'll take that, they'll put it on their format, rearrange the numbers, make it look nice, and they'll put Eagle on it. Okay? But they did not do any R&D, research and development on anything. They had to pay that $10,000. Any leaf spring company that wants to manufacture that same part, they have to go through a certain process in the United States in the automotive industry. Any company can manufacture the same leaf spring parts that Eagle does. But since Eagle's got a contract with the automotive manufacturers, that they can only buy them from Eagle. But anybody can make this product as long as they pay the licensing fee, and they feel that it's a good investment for their company to produce this certain leaf spring. They can sell it as an OEM replacement, but not as an OEM original. Since Eagle is supplying the automated line of manufacturing to the automotive plants, a part of the assembly, they can say that their product is an original OEM. Any other company, they can say it's an OEM replacement, and it's still OEM. Any company can do it. See, leaf springs it's old technology. They make it sound like I ripped off like IBM on a schematic of their new processor. That would be a trade secret. That's where a schematic would be a trade secret. But there's no schematics at Eagle. Okay, so here the evidence is messed up. These documents in the United States and even foreign countries, unless this foreign country has can show that they have a license, and you only get it by paying $10,000 fee, can they sell this product in the United States? Period. I mean, this piece of paper without an actual license is worth nothing. Even if you had the paper, and you can find the spec sheets I had in any Schrader's Automotive Repair book. You can even ask, because of the Consumer Protection Act, you have the right to information. And this the same paperwork I have that they gave to me was never stamped, but it's the same shipping paperwork they give when you order a part from Eagle or a distributor. You'll get your invoice, you'll get the spec sheet, and it'll give you all the dimensions on it for QA purposes and to make sure it installs. There's nothing special about this paperwork. The only reason why it's valued at $10,000 is because of the licensing. You legally are licensed to make this product, and it'll cost you $10,000. Now that's considered expense, doing business expense. And all companies do this. That's like when I worked in electronics at a shop. Before we bought a piece of equipment, is it financially feasible for us to buy this? Okay, if the company that doesn't have a contract with the automotive manufacturer feels that they can turn a profit on a certain leaf spring, they'll pay the $10,000 for the licensing privileges. I mean, nobody will buy this paperwork unless they have a license, because they can't sell it in the United States as an OEM product. Now, you can have a company that can make, because they can just find this stuff in the junkyard anywhere or buy it themselves individually from the company. There's nothing, special about a leaf spring. It tells on itself. Any fool with a fucking measuring tape can tell you all the information on the spec sheet. So Here they're making it out everything. See, the second thing. Well, I put this shit back up online because I sat there. I was like, this ain't illegal for me to have this up there. And here again, they're saying schematics. I never seen them. Now, this is a felony case, and this is incompetent work. And definitely, this person that filled out this, what's their name? Yeah, right there, is not qualified to do a federal case, nor touch a business case at all. They did not do their homework, and they don't mind being embarrassed by showing their ignorance on a certain subject. And here they're saying I'm trying to make something a profit for my own self, a secret. I'm appropriating a secret for my own purposes. It's on YouTube. It's accessible to anybody. Anybody can download it and doesn't have to pay jack crap for it. So how am I doing this for my self-interest? And like I said, the email was pretty dirty, but it never was meant for extortion because due to the evidence I showed you earlier, I was going to win this case. Well, they arrested me, and they make a big deal. Well, he lost that case. Well, yeah, but the second appeal, I was going to win. So they made sure I didn't do that. And here's this person signing off. Yep. She's sworn, da. I wouldn't let these people prosecute a kitty box. Okay, now here is our Attorney General for Oklahoma. Now see, here's where they changed the evidence. This is where he ratted them out. He incriminated Bryan County. It was so cool. These people do not know what they're doing. Now he changed the condition and the evidence. Now he's saying it's a trade secret because Eagle has a contractual non-disclosure agreement with certain customers, Freight Line. Well, the reason why they have this is these are international companies, and their contracts are written to protect themselves from international wrongdoings, because Freight Line knows that unless Freight Line supplies a competitor with, they have to purchase a license, and it'll cost that competitor $10,000, and they can make that part in America. Now, in a foreign country, no, they could lose money on it. But in America, they're guaranteed it, because in America, you cannot make anything unless you do it legally. You definitely can't sell it here, especially on this level of industry, because the automotive industry is locked tight here in America. There's no exceptions. These springs have been around since the 14 and 1800s, man. There's nothing special about them. And in order for this non-disclosure agreement, this is not equal to or qualifies as pre-employment paperwork. Now remember, they're bringing these charges against me after Eagle fired me. And once you fire an employee, they are not responsible for any verbal or written agreements during the employment at the time you are terminated. The company at the time of termination has decided that they don't care about any agreements because they're terminating you. If they cared about it, they'd just discipline you. So the company took it on themselves, since it's a right to work state, to terminate me, which I'm not obligated to the company even for anything. But I never signed one of these. Now this is an actual legal binding document, and I'm going to show you the difference. And so here our Oklahoma Attorney General just ratted Bryan County out, and the evidence has been changed. You can't do that after time of discovery. This is another screw up and proves that these people are not qualified, or some illegal action has been taking place here. Now they're saying theft. They said that larceny. I didn't sneak nothing out. They knew I was taking it out. And since they knew it and didn't challenge me or stop me, I had their consent at that time. I mean, I had acknowledged consent. And in the workforce, that's good enough. They did not bring any witnesses that say that, did you ever come and ask Mr. Hayes for this paperwork and he denied having it? That would be larceny. I tried so many times to give these people this paperwork, and they could pick it up off the ground or find it in Garden Villas apartment complex property when it blew the back fence. They did not care for this paperwork at all. And they cannot be proved to us, trained on anything. Now this is funny too. He comes in here, where's that say? That I had a full orientation, rules, regulations, exceptions, discussing, including, okay, when did this happen? And theft. You know what my orientation was for the 6, 7 people that were there? We all sat in the front waiting area until all of us got there. And then the Hispanic woman, who is the secretary there, once we were all there, she let us through the locked door. We went to this little room that had a table and chairs around it. We all sat down. She handed out folders. And included these pre-employment paperwork. Now, they had us sign them. I asked, well, what if we have a problem with this? One of these things. She said, well, if you don't sign them, no job. Okay, there's a threat right there, so you could legally say this is under duress. But that's it. No films, no training, no discussion. So where's this guy get off making this lie? He's perjured himself. Eagle can't back it up. You cannot make a statement like that without backing it up. That's an accusation, an unfounded and untrue accusation. We didn't discuss anything. She just told us to sign it, turn them in, put them back in our folder. She collected all the folders, and we were left with a little card that said Eagle on it, gave us the attendance number in case we're going to be late or miss a day. On that card, it had our employee number for when we signed in, and it gave us a sheet of paper, what date, time we were, and what department we would report to. And we were given a pair of safety glasses and a plastic juice thing that had a straw in it. And that was it. That was our orientation. So I don't understand where this was all included. Was this on John Richard Roy say so? That you cannot say this stuff unless it is in writing. And I signed off on it. We didn't see any video. This was the shortest orientation, non-informational I've ever been to. And you can vouch that with any ex-employee or current employee at Eagle Suspension. So this guy lied here. So this guy's reputation and his credibility is zero with me. This guy lied. So here's the hiring dependent, heat treat, great responsibility, company policy. This is all a lie. Conclusion, this guy right here has no idea. He's got no credibility as far as I'm concerned. He doesn't even know what business law is. Because in order for me to be held responsible by law, I would have to sign one of these same documents that says disclosure agreement. And the reason why, I'm going to show you what one of them looks like. And it is not your regular standard pre-employment paperwork that you got to sign. Because pre-employment paperwork like that is not legally binding. So we're getting down here and everything like this, and his professional or whatever conclusion, whatever. So here I am, though, back to when I got my sentencing and conviction. And, of course, Campbell, he was biased the whole way. Now, see, this is how they screwed me out of my, tricked me out of my jury trial. Now, I told Jeff Clark at the beginning of the trial, when I seen it going the way it was going, I said, jury trial, dude. Well, the day I had to go to decide whether I wanted a judge or jury, I'm sitting in the jury box wearing my county jumper, and I got ankle chains on, wrist chains on, and Clark comes up to me. Now, I've never seen this happen. He says, your mom wants to talk to you. I'm like, okay. Well, she's terrified, man, when she comes up there, and here's my elderly mom, over 70 years old, and she's worked up. Jeff Clark got her worked up, trying to convince me to take a judge trial. Now, I know who put him up to it. Because they knew if I went to a jury trial, it would have been blown out of the water, man. These people would have been caught dead to rights. Right there. They couldn't carry this through if I included a jury in it. Now, if they could get me to say judge trial, yep, they could do whatever they wanted and get by it. Well, see, at that time, I didn't know what kind of person Campbell was. If I had known then, I wouldn't have gone for a judge trial. I gave him the reasonable doubt, benefit of the doubt that he had some integrity and honesty to him. Well, I found out that was wrong. I don't care. I found that out through personal experience, and I watched him. Because at the end of it, he looked at me. See, he awarded Eagle $100,000 damages when Eagle never provided any, could show any damages. And when Jeff Clark asked him about it, I mean, the only time Jeff Clark did anything was at the beginning when he said, defense Demure. I'm like, what? The hell does that mean? That what a retarded cat says? And then Jeff Clark finally opened up the letters that I sent to him, and had one of them, he looked through it and said, trade secret. He got up there and cross-examined old John Richard Roy. Do you have any patents, or copyrights, or trademarks on any of this shit? And, well, excuse that language. And John Richard Roy said, no. He says, did you stamp any of this paperwork saying company property confidential or anything like you're supposed to? Take responsibility for your stuff? No. By the time, and that was it. That was the only time Jeff Clark stepped up on my side. And that alone should have been enough to put doubt on that. But no, this was in the fix. John Richard Roy stormed out of that courtroom, man. Like a little kid. Poor little kid told him he couldn't have a cookie. He'd dash out of there. Boy, he was harder than shit. He was mad as hell. Because he thought, well, shit, I'm donating, I'm paying for this crap. But sure enough, when it got to where Campbell, the puppet master, I guess, Jeff Clark was so polite, no cross-examination, no nothing. I gave Jeff Clark a witness list. He didn't even do that, so that he didn't call no witnesses. He didn't use any of the evidence I provided him, or any references. I mean, it was hokey, and it's sloppy work, even though it's, you can see corruption and favoritism and everything. It's sloppy work. This guy here told on Bryan County because he changed the evidence up here. This is, oh my God. I mean, I have a winnable case here. It's like handed to me on a silver platter. And at any time, they could have stopped and realized, God, this is so stupid. We're going to get caught. I'm not getting bribed enough or paid enough, or I don't want to lose my career or be disbarred or dishonorably discharged from a judge's position or whatever. And then this was his co-conspirator here. I'm going to turn in a complaint about him and her and the judge, the appeal judge that didn't stop this. I mean, I don't know how far this stuff went, but this is the most sloppiest work. I'd have fired people if they did work like this for me. I mean, right here is where I'd have backed out if I was a DA or judge or whatever, right there where it says schematic. That was like, you don't know what the F you're doing. So, with all this done, and this orientation, this guy vouching for everything. He's talking about how Eagle and everything. I'm going to have a video on that. I think I already have one up there in my account. Okay, now company responsibilities when it comes to NDA agreements. Okay, proper labeling. That was never proper label. And there's things, ABC Corporation. You properly, I already knew this. Limited access. Don't let your supervised, unskilled, entry-level employees touch this paperwork. Are you nuts? If you let them touch it, then you need to be fired. Make sure it's documented. Add a confidential paperwork. This will be an NDA. Make them sign that. See, here's where it follows through. It says, carefully NDA, review, third party, whatever. See, I'm a workforce. I'm third party. You would have to get me to sign it. Watch out for terms. You know, it goes through all this stuff. And this is commonly known crap. Make sure the policy spells out procedure when dealing with. There has to be a written procedure. And you have to train them on it. And you have to sign off. You have to present that. You can't just have what they have in their handout. Here, we're going to pass all that. Here's the handout. This is what they say they were going to get on me. Okay, this is it. This is the most you can do. This is their handout. This is your standard paperwork. This is not legally binding. This is crap. I mean, it's apparent this crap, because most they can do is fire you or suspend you on this. Now, if you still, yeah, that's against the law. Okay, so it says right here and here, it says violating the following rules and regulations or committing any offense referred to below may result in time off without pay or dismissal. Okay, now the whole time I worked at Eagle, right, I didn't violate any of these. Nobody saw that confidential whatever paperwork, which wasn't confidential, it wasn't stamped or anything. This is the one that got me for. Where is it? Something about, let me find it. I think it's on this one. Something about confidential something. I forget what it is. This may be the wrong thing. I think it is. But it's just one thing. I think it was like 20 or something, but I think I got the wrong one. But it has something to do with supervisor what? You hand me this paperwork. You pick it up. The people that pick it up do not take back your so-called confidential paperwork. Are you freaking not training? It's not my responsibility. It's above my pay grade. You can't prove I've been trained in this crap. Yeah, but this is basic standard. This is rules and regulations, so one of them was it. It wasn't that important because during the time I worked there, I did not violate any of these. Now, I wasn't even working for this place when they charged and arrested me, and they fired me on top of it. And I got proof due to the paperwork that, okay, here it is right here, 27. Disclosure of company secrets or company information to unauthorized personnel. Now, see, in the Attorney General, he's saying that I'm supposed to take it back to my supervisor. Where does it say that? Where's the procedure I was trained in to deal with this? What full orientation was I ever at Eagle? Do they have any proof I was ever trained in anything? No. You cannot hold me responsible for somebody else's job. I'm your supervised, unskilled worker. Jesus Christ, these people. Now, this is a legal binding document. If they wanted to hold me responsible for that crap, they should have had me sign one of these. Until you have an employee sign one of these, you cannot, it doesn't make a difference what contract you have with a company has with its clients. That is above my pay grade and my knowledge. I don't know what kind of agreements you have. I am a supervised, unskilled, entry-level workforce laborer. You don't give me anything of any importance. I don't care if I have prior training in the military, because according to federal law, until you pay me for it, I do not have to give you that skill set. I can jack shit up all day. Although I wouldn't, but I can, and you can't write me up for it if you can't show that I have been trained in writing. And you have to have a training program in writing. You have to have duties and responsibilities of the equipment or station you have me operate in writing. That is the law. And this is all federal law. See how long this is just for one agreement? This is legally binding. This is an agreement, contract level, legal. Because look, this, and you can download this off of any website and you can customize it to your web. And this I never signed. So therefore, you cannot hold me responsible. You cannot hold anybody responsible for contracts that a company has with their clients that are not part of the company and have not been trained or signed one of these things. Your standard employee signed paperwork like this is useless. And they use this as evidence. After I hadn't worked there, they fired me and brought this up as evidence that I could be prosecuted on this crap. Are you kidding me? Where's the incompetence level? I mean, they're throwing trash into the wind, smoke screen stuff. And I'm telling Jeff Clark this the whole time, and he's not even bringing it up. He's going to their judge's office with the DA, saying, "Man, we really got to get this undone." And just because somebody thinks that they know what they're doing and tell me I'm guilty of something when I know I'm not, do you think I'm going to believe that? Are you kidding me? I do my job correctly. I am knowledgeable. I know what a trade secret is. I know when people are committing a felony against me. I know when this deck is stacked against me and there is corruption and payoffs going on, and it's evident. And there's also evidence of incompetence, people that do not have any knowledge of anything they're doing. They didn't even prosecute the federal case right. They changed the evidence after discovery. You can't do that. Even in a misdemeanor, you can't do that. And the Attorney General ratted them out right up here. He ratted them out. Like, Freight-Line, none of this is in the original evidence. They don't even have the original evidence right. Why would you go further on this case? Why would a judge put his name to this? I mean, because there's all kinds of, oh my God. Well, my name is Jeff Hayes. I've shown you all this stuff. I'm glad I'm I'm not a judge involved in this case, and I'm glad I'm not a lawyer involved in this case, and I'm glad I'm not the company involved in this case, because bad things are going to come happening here. Karma will pay you people back under no certain circumstances. I mean, it's happening. See, and this I know on my own because I do this for companies. I protect my company from this crap. I mean, I'm more of an expert than anybody probably in this fucking state on business and what you can do and what you can't do and how to keep a company legal. You know, I'm consulting material, man. I've done this stuff. I can walk into just about any company and fix it and make it a better place to work and not threaten anybody's job. You know, look at this crap. I gotta go. This just, I don't know whether to start laughing or crying or be disgusted. But I know things are gonna come up good for me when this hits the fan. I'll tell you what. I mean, I'm not stupid. You can't, after discovery in Oklahoma law, in any state, federal law or whatever, you can't change the evidence. The same evidence you prosecute with, you have to convict with, period. If the evidence is not right, you got to drop the charges, get your act together, and then you can recharge me for it. All right? With that evidence on a felony. But if you don't know what that case is, then don't even step up to the plate, because you're going to look incompetent, stupid, ignorant, unqualified, and look like somebody's paying you a lot of money to look like that. Now, I'm not saying that disrespect to any of the officers, but the people that actually witnessed do this, oh my God. I'm glad I'm not on the state side in this case at all, because I would never get a job anywhere else. And they're probably going to end up getting disbarred and thrown off their bench, because this is going to go to the FBI and through federal prosecution and da-da-da-da, and there's definitely, and see, the Titan Land Management has Eagle's same address, and there's shady things going on in this area. Like I said, I had a friend, they arrested her just long enough to condemn her property and then released her until she, and then the state through Bryan County District Court, whatever, it was shady. The whole thing's shady, and it's been going on in this area. So if these people start showing a profit that they're not making on their wages, at the time Eagle and Titan Land Management Company showed up, there's a connection there. It was so obvious I made it. And I don't even work as a federal investigator. But I tell you what, I seen this as they were doing it. I kept waiting in county, waiting for them to back out of it. I was like, how stupid can you people be to continue doing this? You're getting paid good money under the table for this. This was so lame and stupid. And federal labor law, see, felony right here, big time. That's part of the cover-up. But see, when Drew Hell came with a search warrant, he took both my kids, he took everything. Stuff not even on that list. He was looking for this evidence right here. He was taking paperwork, DVDs. You know what he missed on my wall? On one of those thumbnails or, you know, thumbtacks? There's a DVD up there with a perma marker on it that says specs and documents. Specs and diagram sheets. And he left that hanging on the wall. And it said it right there in perma ink. It's a DVD, a dated DVD, and that was on the wall. And I left those videos up there because if John Richard Roy and Eagle could prove beyond a shadow of a doubt to YouTube, because YouTube has some great lawyers. They can tell you if something's a violation or not. But if John Richard Roy and Eagle could back up their story and had the legal documentation to prove it, YouTube would have took it down. They knew it was crap. And I told Jeff Clark, use that as an example. Here you have a corporation with the lawyers, and they know what they can publish on their website and what they can't, because they're, you know, just a complaint and a hint of evidence, and they'll block it or take it down. I mean, and if any of the members in the community have disreputable actions and stuff, they kick the member off. I mean, if there was something to John Richard Roy and Eagle's, you know, credibility, YouTube would have taken it down. Ta-da! And I told Jeff Clark to say that, because, see, nobody could make me take that down. And I took it down, not to get favor with the court, because I could care less. They had already proven to me they were crooked, corrupt, and they didn't know what they were doing. And at any time, just as soon as they let me breathe free air and free, this was going to happen. Because I'm not going to let people wrong me like this. I'm not going to back down from them. Don't do this to somebody who knows as much as I do, because it's problems. But I won't stand for it. And I let Jeff Clark take it down. I told him, I said it served its purpose. I said you can use that in court. I never told him to take it down to try to get a lighter sentence or something. I could care less. I knew there would come a time where I'd breathe free air, and I'd be free again, and I was going to get them. Because they screwed up so bad on this. They didn't cover their tracks that well. These people should never try any cases outside of your standard, regular, criminal breaking and entering, stealing, drugs, whatever. Simple stuff. Stay away from this stuff here, people. Unless you know what you're doing, you'll look like an idiot. And I think I made that point. So everybody knows what was going on here. Everybody knows who shouldn't be doing what jobs and who should. Now, I've apparently proven my point that I do know what I'm talking about. And I've also pointed out that some people should not be in the positions they're in. And shady things are happening. So, yeah. Troubles are coming. You guys have a good day. This has been Jeff Hayes, and I'll be posting more videos on employees' rights and how to take care of companies by banding together as employees or people who've been discriminated against or witnessed it in these companies around here, by banding together. And, you know, you all have experienced or had done to you the same things. Numbers, it makes it much easier for you to get justice from these companies than if you stand alone. I'll be showing you about that in next and upcoming videos. Alright, because I've had it with this area. I've done my best to try to fix this from within the companies, and when they pull this on me and the companies, like every time I try to help them, you're fired. And then I get blacklisted. You know? It's like, that's what I get. So if you guys aren't going to listen to me, I'm sure the workforce will. Because these companies can't hire anybody anyway. So, whatever. You guys have a good day now. Talk to you later.